There are some instances in which Parliament has deliberately deprived certain persons of the ordinary right of citizens to resort to the King's Courts for the righting of alleged wrongs. The most notorious of these is the Vexatious Actions Act 1896, which provides, "It shall be lawful for the Attorney General to apply to the High Court for an order under this Act, and if he satisfies the Court that any person has habitually and persistently instituted vexatious legal proceedings, without any reasonable ground for instituting such proceedings, whether in the High Court or in any inferior court, and whether against the same person or against different persons, the Court may, after hearing such person, or giving him an opportunity of being heard, after assigning counsel in case such person is unable on account of poverty to retain counsel, order that no, page 834, legal proceedings shall be instituted by that person in the High Court or any other court, unless he obtains the leave of the High Court or some judge thereof, and satisfies the court or judge that such legal proceeding is not an abuse of the process of the court, and that there is prima facie ground for such proceeding. A copy of such order shall be published in the London Gazette." Let it be observed how carefully, even when so high an official as the King's Attorney General intervenes, resort to the courts of justice is preserved, and contrast this with the power of veto uncontrolled which is claimed for the Minister of Munitions. This exceptional statute has been already enforced, as may be seen by reference to in re Bowler 1915, 1 King's Bench 2136. In giving judgment in that case, Scrutton Justice used these words: "One of the valuable rights of every subject of the King is to appeal to the King in his courts if he alleges that a civil wrong has been done to him, or if he alleges that a wrong punishable criminally has been done to him, or has been committed by another subject of the King. This right is sometimes abused, and it is of course quite competent to Parliament to deprive any subject of the King of it, either absolutely or in part. But the language of any such statute should be jealously watched by the courts, and should not be extended beyond its least onerous meaning unless clear words are used to justify such extension. It is to be observed that this regulation not only deprives the subject of his ordinary right to seek justice in the courts of law, but provides that merely to resort there without the permission of the Minister of Munitions first had and obtained shall of itself be a summary offence, and so render the seeker after justice liable to imprisonment and fine. I allow that, in stress of war, we may rightly be obliged, as we should be ready, to forego much of our liberty, but I hold that this elemental right of the subjects of the British Crown cannot be thus easily taken from them. Should we hold that the permit of a departmental official is a necessary condition precedent for a subject of the realm who would demand justice at the page 835 seat of judgment, the people would be in that unhappy condition indicated, but not anticipated, by Montesquieu in De l'Esprit des Lois, where he writes:
Les Anglais, pour favoriser la liberté, ont ôté toutes les puissances intermédiaires qui forment leur monarchie. Ils ont bien raison de conserver cette liberté. S'ils venaient à la perdre, ils seront un des peuples les plus esclaves de la terre.
Livre 2, c. 4. Avery Justice, quote, "The effect of this regulation is that, if any person, without the previous consent of the Minister of Munitions, commences proceedings in any of the King's Courts of Justice of the kind prohibited, he is guilty of a criminal offence and liable to 6 months' imprisonment, or a fine of £100, or both. And the only question for decision is whether this portion of the regulation is ultra vires the statute under which it purports to be made, that is to say, the Defence of the Realm Consolidation Act 1914. This depends upon whether it can be said, on any reasonable construction of the statute, to be a regulation for securing the public safety and the defence of the realm, and particularly under Section 1, subsection 1e, whether it can be said to be a regulation to prevent the successful prosecution of the war being endangered, the latter being probably the most plausible ground on which it might be supported. We have not had the advantage of hearing any argument in support of it, nor are we favoured with the grounds of the decision of the justices. The purpose in view when the regulation was made, namely, to prevent the disturbance of munition workers in their dwellings, may, without doubt, page 836, be said to be reasonable, and a regulation designed to prevent such disturbance, providing that no order for ejectment should be made except under conditions prescribed, would probably be held to be intra vires the statute. But the objection which is made to the regulation, as it stands, is that it deprives the King's subjects of their right of access to the courts of justice, and renders them liable to punishment if they have the temerity to ask for justice in any of the King's courts. It is not difficult to conceive a case in which a landlord might honestly believe that the rent had not been paid, or some other condition of the tenancy had been violated by the tenant, which would justify him in applying to a court of justice for an order of ejectment without the consent of the Minister of Munitions. But if it should be determined that he was mistaken, either in law or fact, he would be liable to punishment for having instituted the proceedings. In my opinion, there is not to be found in the statute anything to authorise or justify a regulation having that result, and nothing less than express words in the statute taking away the right of the King's subjects of access to the courts of justice would authorise or justify it. I have based my judgment solely upon the construction of the statute which confers the power to make regulations. If the question had to be determined as a question of constitutional law, I should agree that this regulation is in conflict with and in violation of the provisions of Magna Carta, cc. 39 and 40, of the Bill of Rights, 1st William and Mary, Session 2, C2, S1, which provides that the pretended power of suspending the laws of the execution of laws by regal authority without the consent of Parliament is illegal, and particularly it would be a violation of the Statute of Northampton, 2nd Edward III, C8, which provides, "It is accorded and established that it shall not be commanded by the Great Seal nor the Little Seal to disturb or delay common right, and though such commandings do come, the justices shall not therefore leave to do right in any point." Shall not leave to do right means shall not omit to do right, notwithstanding that there is a commanding under the Great or Little Seal. In this connection, I think it is not inappropriate to quote a passage from the opinion, though page 337, it is a dissentient opinion of Lord Short of Dunfermline in the case of R. and Halliday, where he says, "Whether the government has exceeded its statutory mandate is a question of ultra or intra vires, such as that which is now being tried. In so far as the mandate has been exceeded, there lurk the elements of a transition to arbitrary government, and therein of grave constitutional and public danger. The increasing crush of legislative efforts, and the convenience to the executive of a refuge to the device of orders in council, would increase that danger tenfold, were the judiciary to approach any such action of the government in a spirit of compliance rather than of independent scrutiny. For these reasons, I hold this part of the regulation to be ultra vires and invalid." End quote. Justice Sankey, quote, "In my view, the words in the statute relied upon as giving power to His Majesty to make this regulation do not enable him to do so, nor is there anything in the Act of 1914 which authorised the making of regulations forbidding access to the King's courts. It is, page 838, true that the power to make a regulation to prevent the successful prosecution of the war being endangered is of a wide and sweeping character, but I decline to hold that Parliament intended to give to the executive the right to close any of the King's courts against his subjects unless they obtained the sanction of a minister to resort thereto. It might have been competent, under the words of the statute, although I express no opinion on the point, to make regulations constituting the consent of the Minister of Munitions, in a proper case, a condition precedent to the making of an order for the recovery of the possession of, or for the ejectment of a tenant of, any dwelling house or other premises of the character referred to. It was not, however, competent for His Majesty in Council to make a regulation enacting that a man who seeks the assistance of, or the protection of, the King's courts should be exposed to fine and imprisonment for having done so. It would have been astonishing if Parliament had conferred such a power as that. See what would have happened in a doubtful case. A man believing in all good faith that he was entitled to bring proceedings finds he is wrong on the evidence, but the mere fact of his having brought them is to make him guilty of an offence and liable to fine and imprisonment. I am of opinion that the regulation so made is beyond the powers conferred by the Act of Parliament. I should be slow to hold that Parliament ever conferred such a power unless it expressed it in the clearest possible language, and should never hold that it was given indirectly by ambiguous regulations made in pursuance of any Act." End quote. R versus Home Secretary, ex parte O'Brien, L.R. 1923, 2 King's Bench, 361. The Restoration of Order in Ireland Act 1920, 10 and 11 George V C31, Section 1, Subsection 1, empowered His Majesty in Council to issue regulations for securing the restoration and maintenance of order in Ireland. By Regulation 14b, made under this Act, quote, "Where on the recommendation of a competent naval or military authority or of one of the advisory committees hereinafter mentioned, it appears to the Secretary of State that for securing the restoration or maintenance of order in Ireland, it is expedient that a person who is suspected of acting or having acted or being about to act in a manner prejudicial to the restoration or maintenance of order in Ireland shall be subjected to such obligations and restrictions as are hereinafter mentioned. The Secretary of State may by order require that person forthwith or from time to time either to remain in or to proceed to and reside in such place as may be specified in the order. Any person interned under such order shall be subject to the like restrictions and may be dealt with in like manner as a prisoner of war. An order under this regulation may require the person to whom the order relates to reside or to be interned in any place in the British Islands." End quote. On December 5, 1922, the Irish Free State Constitution Act, 13 George V, Session 2, C1, was passed, giving the Irish Free State a separate executive. On March 7, 1923, the Home Secretary made an order under the said Reg 14b that Mr. Art O'Brien, who was then resident in England, should be interned in the Irish Free State in such place as the Irish Free State Government might determine, and should be subject to all rules and conditions applicable to persons there interned, and should remain there until further order. Under this order, Mr. O'Brien was arrested in London and taken to Mountjoy Prison in Dublin, and there detained in custody. The Free State government had agreed with the Home Secretary that if an advisory committee appointed for the purpose of the regulation should decide that he ought not to have been deported, he would be released. In an application on behalf of Mr O'Brien for a writ of habeas corpus directed to the Home Secretary, it was held by the Court of Appeal that Reg 14b was impliedly repealed by the Irish Free State Constitution Act, and the order for internment was therefore illegal, and that in view of the agreement between the Home Secretary and the Irish Free State Government, the writ ought to issue addressed to the Home Secretary. Page 375, Lord Justice Banks, quote, The questions for decision in the present case may be divided under three heads. Whether, since the establishment of the Irish Free State, an order can be lawfully made by the Home Secretary for the internment in that state of a person at the date of the order residing in England. Whether, assuming that such an order can lawfully be made, the order now complained of is in form a compliance with the regulation. 3. Whether the application for a writ of habeas corpus directed to the Home Secretary is the proper procedure under the circumstances of the case. It is inconceivable that the order for the internment of the applicant could have been made by the Home Secretary unless he had before him information which in his opinion not only justified but required the making of the order. Presumably also in a matter of this importance he acted upon advice as to his powers. It is a matter of regret therefore that the court should have been called upon to consider the legality of his action. The court knows nothing of the facts upon which the Home Secretary acted, and even if it did it could have no right to be influenced by them. The duty of the court is clear. The liberty of a subject is in question. The court must inquire, and inquire closely, into the question whether the order of, page 376, internment complained of was or was not lawfully made. It is quite clear that the executive of the Irish Free State is an executive distinct from and independent of the executive in England, just as distinct and just as independent as the executive of the Dominion of Canada is from the executive of England. The regulation confers upon a branch of the executive in England certain absolute powers, and among them the absolute power of interning persons without trial, and without, page 377, informing them of the details of the charge made against them, or of the evidence upon which it is made, and for an unlimited period. The regulation is silent in reference to any power of discharge or release, but it is obvious that such a power must be implied. In whom is the implied power vested? Obviously, as it seems to me, in the branch of the executive by whom the power to intern was exercised. I confess to a difficulty in attaching any definite meaning to as much of this regulation as refers to the manner in which a prisoner of war may be dealt with. It must, I think, refer to the manner in which a prisoner of war is dealt with in the country the executive of which makes the order of internment. There can be no possible doubt as to the modification of restrictions, as the regulation provides that they can only be modified by the Secretary of State. These provisions, to my mind, point irresistibly to the conclusion that since the establishment of the Irish Free State, an order cannot lawfully be made by the Home Secretary for the internment of a person in the Irish Free State. The reasons appear to me to be these, page 378. In the first place, because the order deprives the executive of this country of that full and uncontrolled right to direct the release of the interned person, which, in my opinion, is a necessary incident of a valid order of internment under the regulation. Secondly, because the effect of the order is to subject the interned person to restrictions other than those indicated in the regulation, and to restrictions which the Secretary of State has no power to modify. And thirdly, because the interned person is deprived of the particular form of trial which is prescribed by the regulations in the event of his committing any of the offences indicated in the regulation. The view which I have just expressed as to the construction and effect of the regulation is strongly borne out by that part of the regulation which expressly provides that an order under the regulation may require the person to whom the order relates to reside or to be interned in any place in the British Islands. The fact that in August 1920, when this regulation was made, it was thought necessary to make such a provision is, I consider, a powerful argument in support of the contention of the applicant in the present case. Page 381. The last point for consideration is whether a writ ought to be issued directed to the Home Secretary having regard to the contention of the Attorney General, which was accepted by the Divisional Court, that as the applicant was deported to and was interned in the Irish Free State, the Home Secretary had no longer any power or control over him, except insofar as the government of that state had agreed that, in the event of the Advisory Committee deciding that he ought not to have been deported and interned, they could release him. This question cannot, I think, be satisfactorily disposed of unless the rule is made absolute, which will give the Home Secretary the opportunity, if he desires to take advantage of it, of making the position clearer than at present it appears to be. The order, therefore, is made absolute. Page 382. In conclusion, it may not be out of place to observe upon the practice of legislation by means of orders in council that, though the practice may be a convenience to Parliament, it is one which leads to inconvenience and difficulties and dangers, of which the present case is only one example. Laws are made the drafting of which has never been subjected to criticism in Parliament, and when made they are not included in the statute book. The result is that in the first place they are difficult to find, and when found they are more often than not difficult of interpretation, whether it be by a lawyer who is called upon to interpret them, or by a minister of the Crown whose duty it is to administer them. End quote.